Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is the civil bench and motions calendar for August 20th, 2025. All right, so the first case on the calendar. I have a settlement for that case, David Lyle versus Delta Airline, Sodexo Magic. Anyone here for that case, you're free to go at this time. Next case is Obiora Mbachu versus Eric Booker.
Good morning, Your Honor. Attorney Thompson for the plaintiff. Can you hear me?
I can hear you just fine.
Yes, Your Honor, we are here for our Rule 9 side hearing. The procedural history on this case, we had the defendant served on January the 8th, 2024. A return of service was filed February 22nd, 2024. Defendant did not file a responsive pleading. The plaintiff filed for a motion for default judgment June 5th, and a Department of Defense Service Members Civil Release Act SCRA certificate was filed April 25th, showed that the defendant was not on active duty, so the Service Members Civil Relief Act does not bar default.
Okay. Is there anyone here on behalf of Mr. Booker? Okay, the case having been called, Mr. Booker, no representative for him has appeared. At this time, the court finds that the default is appropriate, so we'll grant such. And sir, are these liquidated damages or unliquidated?
Unliquidated damages.
All right. Do you have someone that you wish to put up, or did you file an affidavit?
Yes, we filed well, my client, he is here, and we did file our notice of intent to file medical records, medical bills.
Okay. Did you want to put those up at this time?
If we could wait to the end of the hearing, if you could
That's
give us
fine.
a second, I will. Okay, yes, I'll pull it up. Thank you.
No problem. All right, next I have Jessica Wilson versus Jamario Terrell.
Your Honor, Abigail Moody for Mrs. Wilson.
Anyone here on behalf of Jamario Terrell? My understanding is I granted default as to liability. These are unliquidated damages. So, on behalf of Ms. Wilson, do you have someone that you wish to put up now to prove damages?
Yes, Your Honor. And I also entered some exhibits that have the medical bills, the medical records, and a few other things. So Ms. Wilson is here. I'd like to call her if that's okay.
All right, Ms. Wilson.
Good morning.
Good morning. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Counsel for witness.
Okay. Ms. Wilson, will you just tell us your full name for the record?
Jessica Wilson.
Okay. And tell me, what do you do for a living?
Accounting.
Okay. And did you have that same job at the time of this accident?
Yes.
Just will you tell the court what happened on your accident on February 6th, 2024?
I was traveling north on Anvil Block Road, and a horse came from somewhere and hit me, caused a crash.
Okay. Ms. Wilson, I'm going to share my screen with you and just show you a picture that I had marked as Plaintiff's Exhibit 1. Your Honor, can I do that?
You may.
Let's see. Sorry, I'm trying to pull it from my computer. It's a little tricky. Sometimes, yeah, this is the same thing. I'm sorry. Try. Okay, Ms. Wilson, do you see the picture that I have marked as Exhibit 1?
Yes.
The picture of your vehicle after the accident.
Yes.
And was there damage to your vehicle there prior to the accident?
No.
Okay. Okay. Miss Wilson, did this accident knock you unconscious?
Yes, I believe briefly, yes.
Okay. And when you came to, what do you remember?
I remember the car still rolling and me having to brake to stop it and tasting blood, and I wasn't able to see, open my eyes to see exactly where I was. I was able to squint to, kind of see, but it was very painful.
Okay. And why couldn't you open your eyes?
Um, I believe it was glass in it, in my eyes, that allowed me not to be able to, see exactly where I was. But I was able to squint enough to see that I ended up on Anvil Block Road uh, at Clayton County Police Department in the yard.
Okay. And do you remember who found you?
I heard an unfamiliar voice asking me if I was okay, and I didn't know exactly who it was. And at that point, I told my phone to call my husband. And shortly after that, it seemed I heard the voice of my son saying mom. And then I heard my husband say, go to see if there's anybody in the precinct. That was it.
Okay. And then what happened after that?
I believe the first voice was calling 911 for me, or I tried to call them, and it just seemed like they wasn't coming. But the first responders were at the horse. They didn't realize that the car had been knocked maybe like 100 feet away, so they didn't see me. They were all at the horse and was wondering what hit it. So
Okay.
my son went to where they were. He walked to where they were to say, "My mother is up the street, is down the street," and that's when they came.
Was your
To
son in that collision with you, Miss Wilson?
No, he came with his father.
Okay, he came to the scene when you called him.
Yes.
And I hope you listen to it twice so you.
Ms. Glover, I'm going to ask you to mute your device for me, okay?
Thank you. I'm sorry.
Go ahead, Miss Wilson. I'm sorry.
Okay. Miss Moody, what was the question?
Okay. Did an ambulance come to the scene?
Yes.
Did it take you to the hospital?
Yes.
Okay. What did they do for you at the hospital?
And well, it was a lot of noise, it was kind of chaotic. They took me to the trauma unit, and the first matter of business was trying to get the glass from my eyes. That took a little time. And then after that was achieved, they took me for scanning, like I think a CAT scan and other things.
Okay. And did they do anything like a catheter for you?
I think it was a Puric thing. To where like if you urinate in it. Is that what you're asking?
Yes, ma'am.
Okay.
Okay. All right. Miss Wilson, I want to show you another picture that I've marked plaintiff's exhibit 2. Share my screen with you again. And will you just tell the court what did you see that, Miss Wilson?
Oh, yes.
Okay, and what's that a picture of?
That's the picture of my forearm after the accident. Well, I believe that was a couple days after it.
Okay, and that's 2A.
Mm-hmm.
Okay, and then 2B, what would that be a picture of?
It's abrasion after my leg, on my leg.
Okay. And then 2C, what would that be?
My busted lip.
Okay, and then 2D, what's that a picture of?
my lip with stitches.
Okay. All right. And then after you left the hospital, did you have any other medical treatment, Ms. Wilson?
No, I didn't go to the doctor after I was discharged from the ER. But I did go to get chiropractic care.
Okay. And how long did you treat with the chiropractor?
I want to say about 25 visits, 20 to 25 visits.
Okay. The records say that you went from February when the accident occurred through May.
Yeah,
Correct?
yes, yes.
Okay. And tell me what it entailed going to one of those visits.
So I would get on like do the bicycle, and then I would do the some stretching exercises. Then I would go to the massage bedroom and get like a deep tissue type massage on the bed, and then I would get an adjustment.
Okay. And did you ever have any MRIs done?
Yes, I did.
Okay. And what were those of?
Uh, my lower back, and I think maybe my neck. But yeah, my lower back for real.
Yes, ma'am. Do you remember what those showed?
Well, it showed that I had like a bulging disc.
Okay. And did you get any other treatment for your neck or back?
No, I just continue to go to the chiropractor and do the exercises that he recommended I do at home.
Okay. And did you take any kind of medication at home?
Yes, I continue to take the Flexeril that was prescribed, the naproxen, and sometimes ibuprofen 800.
Okay. Do you still deal with any of the pain or symptoms that you had after the accident today?
Yes.
Okay, where? Okay.
Oh, my shoulder is a big part. If I reach or do something the wrong way, like if I just try to reach behind my back or anything, or lift my arms up, it's uncomfortable. I can feel like maybe cracking, or I don't know the words to describe it, but it's like I can feel clicking in
Okay.
my joint of my shoulder.
And how often does that occur?
Um, Almost daily. It just depends on like what I'm trying to do. I mean, almost daily. Like if I put my purse in the back seat of the car, or I mean on the floor or something, and I reach around to try to get it, I'm like, oh, I know that I reached the wrong way on the right side.
Okay.
Um,
Okay. And besides the medical treatment, did you have any dental treatment as a result of this accident?
yes.
Okay, tell me about that.
Um, well, I went to see an endodontist because I was experiencing sensitivity in around my front tooth on the right. And there was some separation between like the gum and the tooth, and so he recommended a root canal, but he couldn't do it because my lips were still swollen, and it was painful for me to have to hold my mouth open, to have my mouth open to do it right away. So I had to wait a couple weeks before I had to get the root canal to try to take the nerve out so that I wouldn't experience that sensitivity in my tooth.
Okay. And then did you see anyone else besides the person doing the root canal?
Yes, it was recommended that I go see an oral surgeon because my lip was still puffy. And so I went to an oral surgeon and they did an x-ray and there were some particles in there. So they recommended that they be removed. So I had to get that scheduled and have that done. Mind you, that was a couple months after it healed, like in April when I had that done.
Okay. And do you still deal with any problems in your mouth that you relate to this accident?
Well, I feel like, my lip is still on the right side where they removed the particles. There's still a little, it didn't go all the way down because there's still something in there. But they didn't realize that. I didn't notice that until after they had stitched everything back up. So, yeah, and I feel like I don't feel like my smile is straight anymore. It's it's off. It's not centered because I'm not able to. I can feel like it's something there. It's something in my lip that makes it. Uh, it doesn't feel right.
Okay. Do you have any scarring as a result of this accident?
Well, I still have the part of the bruise that was on my right forearm. Is still there. I have been using some vitamin E oil to try to, get it back to the color, but it's still there. And I still, whenever I apply like matte lipstick or something, it doesn't go on smoothly. There's a little hump there on the right side.
Okay. Ms. Wilson, I'm going to show you one more thing. It's a itemization of your medical bills. Is this list of bills correct to your knowledge?
I'm sorry, y'all. I have progressives and they don't work real well at this distance. So if I'm squinting, I'm just trying to find the sweet spot.
No problem.
Okay. Yeah, I mean, to my knowledge, it looks correct.
And that's plaintiff's exhibit 3A, and then the bills are underneath that. And then Ms. Wilson, do you have any chipped tooth as a result of this accident?
Yes, I still do.
Okay. And then Ms. Wilson, I also submitted the medical records as exhibit 4, and are those correct to the best of your knowledge?
Um,
I can show you the start of
let's see.
see. Sorry, I'm trying to share it. This is just the start. This is the arrowhead ones, and then it goes through all of them.
Yeah, so those are the medical records?
Yes, ma'am.
Oh, yeah.
Ms. Wilson, will you just tell the court how this accident has affected your life?
It makes me very nervous to drive. I'm jittery, whenever I feel like everybody's gonna hit me or something's gonna come from somewhere and I'm gonna have another accident. It's just I don't drive at dark anymore. I feel like I'm more dependent on my husband and family when it comes to driving now. So, and then sometimes I just want my lipstick to go on right and it doesn't. So I don't know. Those are just a few things. And then if I don't even carry a backpack anymore because I can feel the weight of it on my right shoulder. So I'm using it like a rolling bag or stuff for my work things.
Okay. Ms. Wilson, before this accident, had you ever had any medical issues with the parts of your body that were injured in this accident?
No,
Okay. And at the time that this accident occurred, were you being treated for any other medical condition?
no.
Okay. Your Honor, I don't have anything further for her. I don't know if you do.
No, ma'am. Well, one question, Miss Wilson, did you see the horse before it impacted you, or did you just, next thing you know, you're rolling somewhere else?
Yes, I did see the horse and I tried to avoid it, but it was like he got spooked. I don't know. But he was following my headlights or something. And I'm thinking, I mean, I have nowhere to go. Like, what am I? It never, that's a road I travel all the time.
And there was nobody on the horse, just the horse running free.
There was no one on the horse. Like, it's like the horse came out like a deer. Like, I mean, it just came like.
Okay. All right, counsel, what's the total that you're seeking?
Your Honor, so want to see, especially in general. So the specials are 62,493.73, and then of course for generals, it's the enlightened conscience of an impartial jury, which of course Your Honor's an experienced judge. So it's whatever you think. But I would say for future medical bills, she may have any kind of injection or oral surgery or chiropractic care in the treatment in the future. Say 10,000 for that. And then I would say, just the trauma of all of it. I think 4 times specials is some reasonable. That's about 250. So all of those together are 322, 493.73. Also, Your Honor, we have to get this judgment enforced. So as you see, the defendant's not here and there's no insurance. So, it's going to be a challenge to do that as well. So I would be seeking 322,493.73.
Okay. So the court is going to award $325,000. And if you just submit that judgment plus cost, we'll go ahead and get that signed.
Thank you, Your Honor.
You're welcome.
Thank you.
Are we free to-
Ms. Wilson, I hope, things get a little bit better. I know how hard it is. I've had deer, like I had a deer hit, I was driving and the truck coming in front of me. The deer jumped in front of that truck and it just exploded out of nowhere. I didn't even see the deer. So I understand that, fear of the driving and driving at night and the headlights and so I wish you well and I hope your recovery continues.
Thank you, Judge Tammy.
No problem.
May we be excused?
Yes, ma'am.
Thank you.
Thank you.
All right. All right. Next case on the calendar. Somehow I've lost where I was on my calendar. Oh, there we go. Okay, so that was the third case. Fourth case on the calendar is Casten Cruz and Ada Melina Casten Cruz versus Darius Nellums.
Yes, Your Honor, this is Luke Kennedy for the defendants.
And
Right.
Tristan Gillespie for plaintiffs.
All right. So, Mr. Gillespie, when we were reviewing your documents, your your motion, some of the cases weren't making sense.
Oh, goodness. I'm happy to review that and fix whatever needs fixing.
All right, Mr. Kennedy, did you have that issue? Because we were trying to.
I did, Your Honor, and that was something that I wanted to bring up today. So that's part of the reason why I didn't file a reply is because I was starting to look at these cases that were cited, and they appear to be I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. And so, for example, Your Honor, on page 2 of the response brief, the Kaplan versus Banks case, I cannot find any case by that name. And
neither could my staff attorney, and she started to question herself. She's fairly new, and I said, "No, you've done this before, so let's just ask questions." So, Mr. Gillespie, none of the cases made sense.
Sure. I'm pulling it up right now, Judge. Bear with me one sec.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as the Georgia Court of Appeals case from 2008. The Zoom is sucking the speed out of my computer. Just hold on one second. I'm trying to actually pull up the case itself. Hold on.
I'll be back in a
Well, let's see here. Look at this. Okay, and also Roland v. Say. I don't know if I'm pronouncing that properly. Let's see.
Judge isn't back yet. Tristan,
I'm back.
There we go.
Okay. So the site I have is Kaplan v. Banks, 289, Georgia Court of Appeals, 193. It's a 2008 case. Got some quotes from it. Big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute providential cause or excusable neglect under OCGA 91155B.
All right, Mr. Kennedy, tell me where you had issues, and then maybe I can tell you where I did.
As far as the citations go?
Yeah, because the case law, like I said, I wasn't, some of it just wasn't adding up, or I wasn't able to find the sites that were listed.
So that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Roland versus Say case right after that, 213, it's cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default. The Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what it was cited for in plaintiff's response brief. Collier versus State Farm Insurance Company, I did find a case by that name, however, not at the site that was listed in the brief. It was not at 248 Georgia App 264. However, the Collier versus State Farm case was just an insurance contract interpretation. It didn't have anything to do with an answer deadline or resetting the clock, as was cited in the brief. And then the last one I noted was Somerville versus Innovated Images LLC, which was cited by plaintiff and has actually been overturned by Bowen versus Savoy, Georgia, which is 308 Georgia 204 in 2020, which was pointed out in my brief. And Your Honor, I would just also say the timing of the filing would kind of raise some red flags for me as well. And you can, I'm hesitant, I don't want to cast aspersions, but I've seen this has started to become a pattern where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment, and that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again, I'm not trying to cast aspersion, I'm just telling you facts. So he's been suspended in Maryland, and part of that was for lack of
Hold
candor.
on, where is he?
It appears that he either dropped off the Zoom call or lost internet connection, Judge.
I think he's coming back on. Hold on, let me see.
Okay.
Yeah. Mr. Gillespie?
Sorry, I went, I got knocked out. I think I'm using too much of my computer's bandwidth or something right now.
So, Mr.
Please.
Gillespie, I'm a former
Yeah.
staff attorney for 2 Superior Court judges. So, and the staff attorneys I'm privileged to work with are really, really thorough, and we check
Okay.
everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess Chat GPT or whatever the legal version of the AI, research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've, resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5 different states. I'm a 2nd-generation lawyer. I practice in 1 state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You got to practice where you know and where you can be proficient at all of the rules. And so my issue has always been attorneys need to know the rules of where they practice and be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me.
Yep.
You risk a reputation, and as lawyers, that's really all we have is our good name and our reputation when you are trying to do too much. And so this brief concerns me because your client is owed a duty of representation, and you owe a duty to be true to the rules of the bar when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than I'm happy to provide additional briefing copies of the cited cases. Whatever.
I trust that Mr. Kennedy went to a law school, if not the same one I went to. I trust that my staff attorney went to a law school, and reading, research, and writing is the first thing you learn. So if 2 lawyers are telling me that they've had issues, then additional briefing is probably not going to help.
Understood.
I need some kind of understanding of what we're dealing with.
Okay. Well, very good then. Should we? How would you propose we proceed?
Mr. Kennedy, this is also your client's case. Talk to me.
Yeah, Your Honor, I was mulling kind of what to do about it and what to ask for. And again, some of the stuff is going to relate to the summary judgment motion, which is not necessarily before you at this point in time. I would at least ask for my client's fees to be reimbursed for having to be here and respond to the motion or the response brief itself, which I don't have that number right in front of me, but I'm happy to supply an affidavit of what that is. Beyond that, I'm not sure if I don't want plaintiff herself to be penalized. So I just want to put that out there. I don't think she should be penalized because I don't necessarily think she has anything to do with this necessarily. It is more.
Well, the brief would, as I understand the statutes, the brief would constitute direct contumacious behavior before the court, which would result in a contempt finding. I wouldn't have to do much extra because it was presented to the court and the contumacious behavior is written in written form before the court. So I would definitely, always back myself up and look again at the statutes before I make a decision, especially on a contempt. But I do believe that in this case, sanctions are warranted, and especially attorney's fees. So go ahead and present your affidavit, and then we'll make a decision on what's to be granted. But Mr. Gillespie, I say this, and I've said this, like literally my family's replete with lawyers. My brother's a lawyer, my mama's a lawyer, my uncle's a lawyer, I'm a lawyer. The one thing that's been drilled into me my whole life is in the practice of law, it's the only thing you have is your good name. And when you're trying to do too much is when you usually risk losing that. And I get trying to practice in a lot of different areas and do a lot of different things, but it is hard to be excellent when you do that. And so I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And so there may be consequences that result from that.
Understood.
All right. All right. So what we're going to do is continue this hearing. We'll give you a date certain for the rest of the hearing. Mr. Kennedy, go ahead, and maybe by that time the summary judgment motion will have caught up with the court. Mr. Kennedy, go ahead and present your request for attorney's fees and sanctions, and the court will consider that as well as any further action I have to take. But Mr. Gillespie, I just judges talk, and so if you practice in multiple jurisdictions, the word will spread, and so I just caution you to be mindful of that.
Thank you.
All right.
So, Your Honor, just to make sure I'm understanding, so we're just going to set another hearing where we'll take up the rest of this motion as well as probably the summary judgment. And I know plaintiff filed a motion to withdraw deemed admissions, from RFAs.
I got it. I reviewed it.
Okay, and I know that's not right, but either. So we just want to take all that up at one time down the road.
Yes, please. And I'll set you all separately.
Okay.
Miss Powell, if you could just give me a date, maybe, some time out, and when we get the summary judgment motion, and then let's hear this case separate from any others.
Yes, ma'am.
All right. Thank you.
May we be excused, Your Honor?
Yes, you may.
All right. Thank you.
Thank you.
Thank you.
All right, next case on the calendar. Excuse me. All right, that was, I think, case number 4.
Yes, ma'am. We're on position.
Okay, next is GSLS Georgia LLC versus Tamika Lorena Sears. GSLS Georgia. I thought I said that. Okay.
Yeah, I'm here.
All right. So, Mr. Martinez, what is GSLS?
It is an entity. Basically, the parent company is SWE Homes. We sell homes in Texas and the Georgia area. It's owner financed.
All right. So it's not a real estate brokerage. It's your like rent to own?
In this sense, yes. In Georgia, there's a contract for D, so it's a rent-to-own situation.
All right, and Tamika Lorena Sears. Tamika Lorena Sears. All right, I did not have.
I did see Miss Sears online earlier.
I saw Tamika, so I was holding for her, but she may have gotten kicked off. Is this a case that's in default? Let me go back to the brief.
It was transferred to state court because I believe because of the counterclaim the defendant is asking for exceeds their limits.
Okay. All right, let me call the rest of the calendar. I'm waiting for I saw Miss Sears, or I saw a Tamika, I thought. So let me call the rest of the calendar and we'll come back. InTown Suites Management versus Sierra Renee Portis. Anyone here on behalf of InTown Suites? Anyone here? Oh, Miss Portis is here. Miss Portis?
Yes, ma'am.
All right, may I see you, please?
I'm on my laptop. My camera does not work on my laptop. I tried to get it to work, but it will not connect.
All right, so anyone here from InTown Suites Management or on behalf of InTown Suites Management? All right, so at this time, the dispossessory action filed by InTown Suites Management will be dismissed for want of prosecution. They have not appeared. The case has been called, and Ms. Portis did appear, so that will be a dismissal for want of prosecution.
Yes, ma'am.
All right, so just a few things, Ms. Portis. That means that this particular dispossessory has been dismissed, but it doesn't mean that they can't file again. Okay. If you're not compliant with the lease contract, there still may be issues, or they may file at another time. All right.
Yes, ma'am. I do understand that, but I will be out soon. I'm gonna move back in with family members, so in 2 to 3 weeks, I will be out anyways.
Okay, ma'am. Thank you. And it's
Judge,
always better if, yes.
Before Ms. Portis is released, she did have a counterclaim.
I was looking for that. I'm not seeing it. Ms. Portis, you had a counterclaim?
I just had to answer.
No, I have that, Miss.
Oh, Judge, excuse me. I was looking at the next.
Miss Sears had the counterclaim. Miss Portis did not.
Yes, ma'am. I'm sorry.
All right, no problem. All right, Ms. Portis, you're free to go at this time, ma'am.
I'm sorry, Judge. I didn't hear you.
I said you're free to go at this time.
Thank you.
You're welcome. All right, the next case on the calendar is Riverdale MHP versus Mortimer and all others. That's Ms. Barksdale's case. Did we continue this case, Ms. Powell?
No, ma'am, we declined to continue.
All right, anyone here on behalf of
appearance.
Riverdale MHP?
I'm here.
Okay, who said that?
Good morning, Your Honor. My name is Kadisha Mortimer, defendant and counterclaimant in this matter.
All right. Did we hear anything from Ms. Barksdale's office?
No, ma'am. I'm double checking my email, but there's nothing in the record.
I didn't hear anything, Judge, and that's unusual that she have not appeared.
Yeah,
Yeah.
because she appeared appeared the last two times. All right, so you got Miss Mortimer. Let me see you.
I'm sorry, what was that?
I need to see your video. Do you see you on video? All right.
Hey,
Hello. Um, so this is the last case on the 10 a.m. calendar. So there's a pathos, a dispossessory, and a counterclaim. So, ma'am,
Dismiss this case since she didn't show up, not yet.
Sir, if you're gonna participate in the hearing, then I need to see you. I don't need to have somebody just whispering to Miss Mortimer. Well, I have Miss Lachey. So, are you going to participate?
Because I set this up so she can have a Zoom call. So she's
Yeah, but if you're tech, then be tech. But if you're gonna be tech and legal, then let me see who you are.
okay. How you doing?
All right, so sit down. Are you the all others?
No. I'm her uncle.
Okay, well, then I'm gonna need you to be an uncle and not a lawyer.
Excuse me?
I said I'm going to need you to be an uncle and not a lawyer.
Well, okay. I just told her if the lawyer doesn't show up,
What you
then
told her.
move to dismiss. That's
Well,
it.
she can't move to dismiss. She has a counterclaim.
Yeah. Okay. But the lawyer didn't show, correct?
I'm clear on that, sir.
Okay. I mean, you the queen. I'm just,
I'm not the queen. I'm just the judge who has 30 years of legal practice, and I'm just
Right.
wanting to get on with this hearing.
Yeah,
If you
I'm
would
just walking
allow
through.
it.
I'm just trying to tell her I didn't even hear everything. I just heard somebody not here. I'm just walking through. We had a death in the family, so we're all here. And
So
I'm
did I,
just
sir.
yeah. So
So did I.
I was just being nosy. Sorry about that.
All right, thank you.
Have a blessed day.
You too, sir. All right. So are you Miss Lachey or Miss Mortimer?
my middle name is Lachey. My last name is Mortimer.
Okay. So now, Miss Mortimer, it is my understanding that you all were here before. You, one of y'all showed up, the other one didn't. It appeared that maybe you didn't get noticed, so we scheduled the case again. So this is the reschedule of the case that was on the calendar before. Is that what you understand?
Yes, correct.
Okay. All right. So the claimant for the dispossessory has not appeared, but you are here and you are seeking a counterclaim, and you say that your counterclaim is worth $466,000.
No.
Correct.
All right. So tell me why that is.
All right. 1 second. I would like to speak without interruption. I have wrote some things down, so just bear with me. I'm sorry. And you said why did I do
Okay, let me just explain something first. So we don't just give money just out just without a basis, especially on a dispossessory. So there has to be a basis for what you're asking for. $466,000 seems like quite a bit of money, and I assume that this is an apartment community. So it's not like a standalone home that was totally destroyed by fire or some other catastrophe. So you're saying that you're entitled to $466,000, and it lists on here $25,000 per violation. That's not how we do it. So now tell me what happened and what you feel you're entitled to.
So it started off with the damages, trespassing, the mold, violating.
Okay, one thing at a time.
Okay. So it was the damages.
Miss Jones, I'm gonna need you to mute.
I'm sorry, who was Jones?
I don't know. Miss Jones, are you a part of this hearing?
Yes.
Okay, who are you, ma'am?
If I could interrupt, Your Honor, my name is Paul McCarthy. I represent the defendant in the case that's set for 11 o'clock, and Ms. Jones is the plaintiff. It was set for her counsel's motion to withdraw. So she's not here on this case. She's here on the 11 o'clock case, Ms. Jones.
Ms. Jones, can you mute for me? This isn't your case. All right. Okay, so ma'am, when did you move into the apartments?
Um, sorry, I'm bad with dates.
This is your case.
Yeah, I'm bad with dates, but May 31st, 2004. I'm sorry. 2020.
2004?
Yes.
You've been living there for 20 years?
No, 20, 2004.
2000,
24.
you said 2004. Okay, so you moved in on May 31st of 2004. What was the rent that you were paying?
1,200 plus utilities.
All right. Was there a point at which you stopped paying rent?
You said, was there a point?
Yes, ma'am.
Yes, I did.
Okay, tell me when that was and then tell me why.
One second. Let me check my email. 1 second, okay? It's loading. I'm so sorry.
Okay, can you tell me why you stopped paying rent?
Because of the conditions in the home, which I
Okay,
have proof of the pictures. Would you like to see it?
hold on. No, ma'am. One thing at a time, ma'am. It works best because you're kind of all over the place. So if I guide you through this, it will work better.
All right.
All right. So now tell me what was the first thing that you noticed that you thought I shouldn't be paying rent for
Judge, I'm
this?
so sorry to interrupt. Could we
Yes.
please take a moment in the breakout room, you, myself, and Miss Val?
Okay, 1 second. Miss Mortimer?
Yes.
So I checked, my staff attorney checked Odyssey where notices went, and because you're pro se, you probably got a mailed notice, but the attorneys are supposed to get it electronically. And there's something going on with Odyssey where the notices went out, but it doesn't show that Miss Barksdale got notice of this hearing. Then it's the same thing that happened last time, only it was, I think, you who didn't get notice of the hearing. And for some reason, we're having these issues with our electronic filing system called Odyssey. I'm going to send paper notice to both of you and electronic notice, but we're going to have to put you on another date. But this is what I ask you to do. Hold on, Mr. Thompson, I'm going to come back to you. This is what I ask you to do. Anything that you will have to refer to, just print it out. Like if you have emails that are relevant to what you need, if you have pictures, have it all laid out in front of you, and then sort of have a timeline of what it is happened and what it is you're asking for. You got me?
Yes.
Okay, so you're organized, but you don't kind of know how this all flows. And so I want you to be able to present your case the best way possible. So when you do that, just make sure you have everything printed out, have it in the order that you want to present it. And the way I'm going to ask for things is I generally start with, when did the lease start? What were the terms of the lease? Like, what were you paying? When was it supposed to be paid? Who was responsible for maintenance? That kind of thing. And then you can tell me, why you felt like you shouldn't be paying because of the issues that existed. You got me? Okay, so now watch your mail. We're going to send you notice. We're going to send Miss Barksdale notice, and we're probably going to have to send that by mail because of the glitches with Odyssey. We'll probably have to do both. Okay?
Mm-hmm.
All right, ma'am.
Yes, ma'am.
When you get the notice, like I said, just have all your stuff laid out, and then we'll go through it.
All right. Thank you so much for that.
Thank you. No problem.
All right.
All right. And
May I be dismissed?
Yeah, you're excused at this time. You're going to come back for another date. You're not dismissed like your case is dismissed. I don't have it right now.
Yes, ma'am.
I just set it on what is my next available civil case calendar, but I got a couple that are full, so we'll see what the next one is. Are you in school?
Right. No, ma'am. Oh, thank you, but no.
No, because I just like to, if you're going to be away at school, I want to make sure I can accommodate that also.
Yes, ma'am.
All right. Thank you.
All right. Thank you.
All right, Mr. Thompson, you wanted an opportunity to present Mr.
Mbachu.
Martinez.
Thank you.
I'm sorry.
Mr. Mbachu.
Mr. Mbachu's case, and Mr. Martinez, we had called your case, but the other person had not come back yet. I guess Ms. Sears.
Yes.
All right, so let me go back to Mr. Thompson, and then we'll come back to you, Mr. Martinez, and then that will conclude that calendar. Ladies and gentlemen, if you're here for the 11 o'clock calendar, we had kind of a longer case earlier, so we're going to get to you as quickly as we can. Just give me a little bit of patience. So, Mr. Mbachu's case, did you have a witness that you wanted to present?
Yes, I have Mr. Mbachu here, and I do have my opening statement. We did come last month also, but there's an issue with the notices, and so we are here and we are prepared. On Friday,
Odyssey is kind of hit and miss with some things, and so we're doing the best we can. And I've had this happen a few times. So
well, thank you, because we came twice, and you told me to go today, and he's ready because we've been waiting for this. So thank you. On
You're
Friday,
welcome. I try to make sure notice is the bedrock of due process. So I try to make sure everybody gets notice. All right. So this is Obiora Mbachu versus Eric Booker. Mr. Booker, I did not see present, but Mr. Mbachu, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true? Okay, you're going to have to unmute for me. There you go.
Yes, absolutely.
All right. You can put your hand down, Mr. Thompson, your witness.
On Friday, December the 10th, 2021 at approximately 5:03 p.m., plaintiff Obiora Mbachu was operating his 2017 Honda Accord Touring, traveling southbound on Riverdale Road near Phoenix Boulevard in Clayton County, Georgia. Plaintiff was wearing his seatbelt and operating his vehicle in a prudent and lawful manner. Suddenly and without warning, defendant Eric L. Booker, operating a 2020 Dodge Challenger, erratically changed lanes and struck the left rear end of plaintiff's vehicle. The impact was forceful and violent, directly causing injuries to Mr. Mbachu's body and damage to his vehicles. Mr. Mbachu's conduct and negligence, Mr. Booker's conduct and negligence, and violated multiple provisions of Georgia's uniform rules of the road, including OCGA 4649, following too close, OCGA 46123, improper lane change, 40-64241, failure to exercise due care, OCGA 40-6390, reckless driving. The evidence will show that Mr. Mbachu sustained injuries and medical expenses directly resulting from this incident. Plaintiffs respectfully ask this court to award both economic and non-economic damages based on the evidence presented. Preliminary matters, the liability has been established by default. Mr. Mbachu, will you please state your full legal name?
My name is Obiora, middle name Nelson, last name Mbachu.
Or are you employed?
Sounds like there's somebody. I'm sorry, I didn't hear the question.
Ladies and gentlemen, we can't hear you and your comments. Please make sure that your device is muted. If you look on the screen and you see where your designation is, you should see a red line through what looks like an old-fashioned microphone, and that will tell you that we can't hear you. But if your mic is open, we can hear whatever's going on. Thank you. Go ahead.
Thank you. Are you employed?
Yes, sir.
Where are you employed and what is your position?
I'm currently employed with Cherokee Federal and I'm an occupational health registered nurse.
How long have you held that position?
Since the end of July.
Do you recall the events of December the 10th, 2021?
Yes, sir.
Describe what happened that evening.
That evening, I was driving home. I was working at Grady. As you stated, going south on Riverdale Road. And to my right was Phoenix Boulevard. I was driving and Eric Booker changed lanes very quickly. A car had stopped in front of me, but he switched into my lane and hit me in the back.
Prior to that date, did you have any health issues affecting your back, neck, or head?
Yes.
No. What changed after the collision?
These injuries were re-exacerbated.
Okay.
I had less mobility in my lumbar and thoracic spine. As you know, I work as a registered nurse. I used to work acute care, where there's a lot more lifting, pulling, pushing, that kind of thing with heavier patients in the OR and on the medical surgical floor. And it affected my ability to continue to work in acute care.
Okay. Thank you. Now, Your Honor, I would like to enter our medical bills into evidence.
All right, so this is a default hearing. Mr. Booker's not here to object, so go ahead and you can enter them all at once or one by one.
Okay. Okay, so I go here. Let me attempt this.
You want to share them or you just want to enter them?
I want to just enter them. This
is what we do. So
okay.
Just tell me Exhibit 1, medical records from blank. Exhibit 2, medical records from blank. And just go ahead and list those out and we'll go ahead and enter them. And you can go ahead.
Okay. All right. Thank you. Thank you.
No problem.
I am using two screens. So comes now plaintiff Obiora Mbachu. He intends on submitting the billing statement from Benchmark Physical Therapy dated January 31st, 2025. And I have, let's see, just bear with me. Mr. Mbachu, do you recognize the itemized statement?
Yes,
Does
sir.
he have a copy of it with him?
He has the copy that was filed in court. The copy that was filed with the court. Yes, ma'am. Do you know what it is, this document is?
Let me get to this trial notebook. All right,
So,
what page are you on?
Mr.
Oh,
Thompson,
I'm asking you, oh, I'm sorry. Yes, Your Honor.
most plaintiffs aren't medical experts. I really just
Yes.
need to know if he attended treatment at that facility, what type of treatment he had, and if he's responsible for the bill.
Yes, Your Honor. We're right here. You know, we came in, and so that's why these questions. Okay, Mr. Mbachu, are you familiar with the bill from Benchmark?
Yes, sir.
And how are you familiar with that bill from Benchmark?
It was obtained with a certification of records, and it's something that you and I have reviewed and looked at together.
What is the total cost of the bill?
2262.
Your Honor, plaintiff moves Exhibit A into evidence.
It will be admitted without objection.
Okay, Your Honor, we rest our case. Our closing argument is that the burden of proof is the preponderance of the evidence. Liability has been established, conclusively established via default judgment. The medical bill entered into evidence shows the economic harm Mr. Mbachu suffered. Additionally, the pain and suffer from the collision are ongoing. Under Georgia law, per diem argument is permitted. See McDonald v. Kroger, 171, Georgia Appeals 574, 1984. We request $100 a day for $100 a day for pain and suffering for 365 days, totaling $36,500. So our medical expenses
Is
are
that
22.
inclusive or exclusive of the economic damages, the benchmark bill?
The benchmark bill is inclusive of the medical expenses, not of the general. Those are the actual damages.
Okay.
And for $100 a day at 365 days, $36,500. And for court costs, $277.
Okay, so you're seeking $2,262 for benchmark, $36,500 in pain and suffering, plus $277. This is a default case. There being no objection to those amounts, and those amounts being deemed reasonable by the court. The court is going to grant the total. And if you will just submit an order with those amounts as the total, the court will sign.
Thank you so much, Your Honor. Have a blessed day. Are we permitted to leave?
Yes, you are. Thank you, Mr. Mbachu.
Thank you so much, Your Honor. You have a blessed day, okay?
Thank you. Take care. All right, so Mr. Martinez. So,
Yes.
Mr. Martinez, so it appears that this also is a default. And you were going to tell me, this is my understanding is this is a lease purchase that did not go as planned. So go ahead and lay out your case for me.
Yeah, it was a contract for deed executed on September 1st, 2020. Looks like the last payment we received was on December 15th of 2023. So at this point, it's 20 payments behind. Each payment is $1,823.74. That's principal and interest plus escrow. So total payments are $36,474.80 in back and past due payments.
Okay. Did you all have any other penalties that go along with those past due payments? Were there?
Yeah. Actually, because it's the breakdown is $36,474.80 plus late fees of $1,730.44.
Yes.
But there is a credit, so minus because we put something unapplied, it was not enough to complete a payment of $1,777.98. So it's a total past due amount of $36,427.26. Due for January 1st, 2024.
Okay. So have you has the house been, I guess, relet or engaged in another contract at this time?
No, because it's still occupied, so we can't really do anything until that's what we're just trying to get possession
Okay.
of the property, but we can't do anything until it's vacant.
All right.
We get possession of it.
So you're seeking possession of the property.
Yes.
All right. And is there anything else that you need to tell me about this agreement?
No, I mean it's I included, but the agreement as an exhibit. So that's basically it. I was ready unless if she was here, but that's all we're seeking possession at this point.
Okay. Okay, plaintiff was served and she did respond, but she has not appeared for the hearing. So the court is going to grant default in this case, and denial of her counterclaim of $35,000 due to warrant of prosecution. At this time, the court is going to grant as pled $36,427.26. That includes the arrearage and any penalties for late payments, with the credit granted for payments made, and also possession of the property. So, Mr. Martinez, you're not a lawyer, are you?
No.
So we'll go ahead and draft the agreement, draft the order for the court. Ms. Powell, so that'll be $36,427.26 plus court costs, and possession of the property, because she failed to appear, that will be possession in stanter. All right, Mr. Martinez,
Thank
we'll
you.
get that out to you.
Okay, thank you. Appreciate it.
Thank you. All right, so that concludes the 10 a.m. calendar. For those of you who are here for the 11 a.m. calendar, I'm going to go ahead and start calling that. Thank you for your patience. Cynthia McGee versus Thomas Wright, Hyde Park and Park Construction. Okay, so this is a case that I've seen, like we had a hearing on it before. Are the parties here for that?
Yes, Your Honor. Kyle Fisher for Miss McGee. She is present. She is indicated as 1 plus DE 2118.
Okay. All right. So I know we have a number of defendants, some of whom may have may no longer be a part of the litigation because of decisions made by the court earlier. So let me go through Shy and Park, Thomas Wright and Shy and Park.
They've been dismissed, Your Honor.
Okay. American Improvement
Services LLC. That is what we're here for today on the default hearing.
Okay. King's Roofing Service.
They have been, they filed for bankruptcy.
Okay, so
they've
there's a stay as to King's Roofing Service. Spartan Roofing LLC.
I believe that they are out as well.
Okay. Allen Hills Preservation.
I think they were previously dismissed.
Preservation Partners.
Previously dismissed, Your Honor.
The Walsh Group.
Previously dismissed, Your Honor.
Archer Weston Construction.
And previously dismissed, Your Honor.
All right. And then we have a number of John Doe's. All right. I just want to make the record clear. I do record. And so if there is ever a need for, all right. So here you are here for a default against American Improvement Services LLC. Is that correct?
That is correct, Your Honor.
All right. You want to go ahead and present?
Yes, Your Honor. I have previously just emailed to Ms. Powell Exhibit 1 and Exhibit 2, or pardon me, I will. I'd like to share my screen, Your Honor, for my client. Thank you. Ms. McGee, could you please raise your right hand? Do you swear affirm that I can, we all can. Will you please swear affirm that the testimony you're about to give in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, and can you please state your name for the record?
Cynthia McGee.
Okay, Ms. McGee. We are here because on February 7th, 2019, you were walking out of your apartment and you got hit in the head and the foot by a roll of roofing felt, correct?
That is correct.
Okay. And based on that, you went to the emergency room?
I did.
And where did you go to the emergency room? Was that at Grady Hospital?
Yes.
Okay. Can you see my screen? Can you see a document that shows at the top Grady Health System?
Yeah, I can see
Okay.
it.
And can you confirm that this is the same document that we reviewed yesterday and that these are the bills for your treatment at Grady Health System?
That is correct.
Okay. And I just want to go over the kind of the treatment that you received, and the injuries that you received. When the roofing felt hit your head, is it true that you suffered loss of short-term memory?
Yes, that's true.
And the roofing felt also landed on your foot, correct?
That is correct.
And you had a fracture on your foot of your toes?
Yeah. Yeah, I broke 4 toes, yeah. And it was a big gash on the side of my big toe.
Okay. And in those treatments, Grady Hospital gave you CT scans. They wrapped your foot. They gave you a boot on your foot. It took about 6 weeks for them to treat you, correct?
Yeah. I had a cast before I had the boot.
Yes.
And before the cast, I had the wrap.
Okay.
Okay.
And in addition to the injuries to your foot, your short-term memory came back after about 3 months, but you also sought psychological treatment for the trauma that you suffered from the roofing felt falling on your head?
Yeah, absolutely. My anxiety had went up really high every time I hear noise of like construction. And yeah, I had to go talk to a psychiatrist and therapist and yeah, it was dramatic.
Okay. And so these bills with Grady, they amounted to $35,351.64.
Yes, they did.
Okay. I want to move on to, in your honor, I'd like to introduce that as Plaintiff's Exhibit 1 for the
Will
record.
be admitted without objection.
And Ms. McGee, could you please can you please confirm that this is a copy of your ambulance bill with Grady EMS?
Yeah, that's it.
Okay. And as we went over yesterday, the bill for the services that was provided you to transport you from the apartment where you were injured to Grady amounts to $1,947.75.
Yes.
Okay.
That is correct.
Your Honor, I would move this this EMS bill into evidence as Plaintiff's Exhibit 2, please.
Will be admitted without objection.
Okay. And Ms. McGee,
Yes.
on these bills, are these 2 bills, they amount to a total of $37,915.39. Is that your understanding?
Yes, sir, that is.
And do you believe that's a reasonable charges for the services that were provided to you by Grady EMS and Grady Hospital?
I do.
Okay. I would like to move on to how this injury has affected you. You indicated, or you agreed that you suffered short-term memory for a period of time.
That is correct.
And how long was that for?
Maybe about 3 weeks or something. I can't remember how long it was. I
Okay.
know okay.
Did it affect your long-term memory?
No, I don't think so. I don't remember. I just, like I said, when I had the accident, my phone had broke. So my daughter the next day took me to get my prescription and another phone. And so when I was looking at my phone, I couldn't remember who these people were on my phone. I mean, the names were there, but I couldn't remember who they were.
Okay. But you ultimately were able to remember after about 3 weeks or so?
The next day I couldn't, but 2 days later I started losing my memory.
Okay.
And it lasted for like, you right, about 3 weeks.
Okay.
Because I had to go get a CAT scan. Yeah. Yeah.
Yes, ma'am. Also want to ask you for your pain and suffering in the moment. And this may sound like a dumb question, but was getting hit with that roll of roofing felt painful?
Yeah, it was excruciating pain. And I couldn't stop screaming, and the police and the ambulance kept telling me to be quiet. I mean, to stop screaming. And I was like trying to tell them that I was in that much pain. And so, yeah,
Was that
it
one of
was,
the most traumatic experiences you have ever experienced in your life?
oh my God, yes. And to make it so bad, they wait till I get 100 and then I have an accident.
Yes, ma'am.
Yeah.
Let me ask you, with regards to your future pain and suffering, do you have any pain right now in your head?
No.
Okay, so you don't have any headaches or anything like that, correct?
Correct.
Okay. What about your foot? Can you explain to the judge what type of pain you suffer in your foot?
Oh yeah, like when it rains, it throbs. It's like a ache. It's not like a pain. And it's really uncomfortable. I mean, I have to just like sit down for a while and elevate my foot so the pain. I mean,
Yes,
well,
ma'am.
it's not a pain, it's like a ache or a throb.
Yes, ma'am. And Miss McGee, how old are you right now?
I just made 68, August
Okay.
15th.
And this incident happened 6 years ago, correct?
That is correct.
And in addition to the initial pain and the pain that you had with the cast and all of that, you've suffered this throbbing pain when it rains for the past 6 years.
That is correct.
Okay. And your life expectancy is you certainly will live to be the age of 78, correct?
Yeah.
Okay. And let me ask you, you're retired now, aren't you?
Yeah.
And what did you do at the time of this incident? Where were you working?
Oh, I was working at the Georgia World Congress Center,
Okay.
and
And how
I
much?
did security. I did
Yes, ma'am.
security.
How much did they pay you at your job?
14 an hour, $14
For,
an hour. Yeah.
okay. Um, Your Honor, I have no further questions from Ms. McGee. May I make an argument? Or if the court has any questions?
No, ma'am, but I was just shocked when she said 100. I was like, oh my goodness, you type scribe for 100. No, ma'am. No, I don't have any questions. Go ahead, sir, make your argument.
Yes, Your Honor. Based on we would obviously request a judgment for economic damages in the amount of $37,915.39. And we would request pain and suffering, past pain and suffering in the amount of $52,000 for the actual incident. That would be a multiplier of 1.5 times the the medical expenses. And then for future pain and suffering, Your Honor, from the date of this incident, we would request a per diem amount of $14 an hour times 2,000 hours, which is $28,000 a year for the pain that she suffers from the throbbing of her foot for a period of 16 years. And that amounts to $448,000 for future pain and suffering.
Right. What's your total, counsel?
So that would be 500,000 and $37,000, 915 and 39 cents. So $537,000, $537,915.39.
All right. Counsel has come and pled with records and with a witness, the plaintiff, the economic damages, the information provided was reasonable with respect to the fact that there isn't anyone to dispute any of the amounts given or the requests made. Court is going to grant the amount of $537 and $537,915.39 total plus court costs. And sir, if you would prepare that order, then we'll go ahead and get that signed for you.
Yes, Your Honor. And as an administrative matter, at some point, American Improvement Services, LLC, the word home got inserted there. I don't know when that happened.
If you would like to put a line in there about a misnomer,
yes, Your Honor.
Court correct misnomer, then we'll go ahead and do those at the same time. Just do one order.
Yes, Your Honor. Thank you so much. I appreciate it. And I have no.
It's always best.
Yes, Your Honor. I have no business, more business in front of this court. May my client and I be excused, please?
You may.
Thank you, Your Honor. Ms. McGee, thank you so much. You can hit leave the meeting.
All right, thank you so much.
All right,
Thank you.
Ms. McGee, I wish you well. All right, ladies and gentlemen, just give me 1 second and I'll be right back to continue the calendar.
Excuse me.
Yeah.
Hi, I was trying to find the staff attorney's email.
Oh, okay.
I responded to your chat, Miss Mortimer. If you just look at your
yeah,
chat
that red
notification,
box with the white number in it, that's for you. So click on that. And that should have, like, I think I sent you a message asking if you were okay, if you needed anything. But if you look at that, you should have her email address in that white box. And do it before you leave, write it down, because you're not going to be able to remember it.
Wait, what white box?
No, there should be a red box with a white number in it. Look on your screen. You see that anywhere?
Yeah, but the chat is empty. Oh,
okay.
I got it. I got it.
There you go.
All right, I have it. Thank you so much.
No problem. Make sure you write everything down before you leave.
All right, I will.
All right, thank you.
You're welcome.
Deputy in the courtroom. If there's no one in courtroom 304, you guys can shut it down and be excused.
I have a case in courtroom 304.
Thank you, Your Honor. We're clear.
Yes, everyone that's on Zoom, stay on Zoom. I'm speaking to the deputy. If there's no one in courtroom, you guys are good to shut down, deputy.
We're clear. Thank you. You have a good day.
You too. Thank you.
All right, ladies and gentlemen, so that was the first case for the calendar. Second is Zoletta Jenkins versus Latanya Hurt and Dalgan Corp. LLC. Is there anyone here for Zoletta Jenkins?
They settled, Judge.
Okay, so that case is settled. Charles Ferguson versus Andrew Andrews and Dress Lawnmower Repair.
Good morning, Your Honor. Attorney Barnes on behalf of Mr. Ferguson.
Hi,
And
Ms.
he's
Barnes.
on. Hey, how you doing, Judge? Good to see you.
Good to see you. All right, and is there anyone here on behalf of Andrews or Dress Lawnmower Repair? All right. Ms. Barnes, go ahead and present.
Yes, Your Honor. Thank you. Okay, Mr. Ferguson, you can take yourself off mute.
Hold on a second. I'm going to send you something and it might help, okay? If you see a prompt on your screen, just follow that. There you go.
Okay.
Thank you, Judge.
Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down, sir. You're a witness, Ms. Barnes.
Thank you, Your Honor. Okay, Mr. Ferguson, could you please state your name and full name and address for the record?
Yes, my name is Charles Ferguson. Address is
He doesn't have to put his full address.
No, yeah, not excuse me, we're on Zoom, not full address.
We can skip the address part.
Okay.
Not
And you are the plaintiff in
the case.
Okay, and you are the plaintiff in this case, correct?
Yes.
All right. And on August 17, 2023, were you bitten by the defendant's dog?
Yes.
Okay. And tell us a bit about what happened.
I was going to get a lawnmower repair. The place was not open. It was opened up at 9. I did my errands, came back, and someone was inside. I walked in and opened the door. The dog jumped up and bit me on my forearm. So yes, that's about it.
Okay. And what type of dog was it?
It was a pet bull.
Okay.
A pit bull.
Okay, and whose dog was it?
It was the owner's dog.
All right. And that's the defendant, correct?
Yes.
All right. And did you seek medical treatment for the dog bite?
Yes.
All right. Where did you receive medical treatment?
At South Region Hospital in Clayton County.
Okay.
Okay, yes.
All right. And can you please describe the treatment that you received?
Yes, they cleaned the wound, and then they took needles and put it inside the called it a he penetrated through the forearm, punctured the skin, and they gave me rabies shots right then and there, and clean up the room, and other shots I cannot recommend. I cannot, but I know it was 3 shots they gave me at Southern Regency emergency room.
Okay. Yes. Did you receive any follow-up treatment?
Yes. Yes.
Okay. And what follow-up treatment did you receive?
I had to do like 3 treatments at Decatur health clinic in Decatur, and I had to do like 3 sessions of rabies shots.
Okay. All right. And was there any other treatment, or was that it?
That was it.
Okay.
That was it.
All right. Yes. And Your Honor, at this time, I would like to share my screen to put up the first exhibit, and I sent the exhibits to yeah. So I'm going to go ahead and share my screen now.
Go ahead.
Thank you. Okay. Mr. Ferguson, do you recognize this document?
Yes, yes.
Okay. And what is it? And I could,
This is a bill, yes.
all right,
Medical bill.
and all right, where's the medical bill from? Is it from Southern Regional Medical Center?
Yes,
All right. And is this bill in the amount of $62,013.74?
yes,
All right. And is this a true and accurate copy of the medical bill you received?
yes.
All right. Your Honor, at this time, I'd like to move to admit Exhibit A into evidence.
It will be admitted without objection.
Thank you. All right. So next, I'm going to show you another bill.
Okay.
All right. And I'm going to blow this up. I know it's kind of a bad copy here.
Yeah, because I'm already struggling with my little with my
I'm blowing it up.
bifocals.
Yeah. So, okay. Do you recognize this bill here?
Yes,
All right. And is this bill with the DeKalb County Board of Health?
yes, yes, yes,
Okay. And is this bill in the amount of $33?
yes,
All right. And is this a true and accurate copy of the medical bill from DeKalb County Board of Health?
yes, it is.
All right. Your Honor, I'd like to move to admit Exhibit B into evidence.
Will be admitted without objection.
Thank you. All right. And next here. All right. So one on the bill here. Do you recognize this bill? Is this the
Yes,
bill
I
from
recognize
Small?
it. Yes,
Okay. And is this bill from Small Hospital Innovations?
yes,
All right. And is this bill in the amount of $1,324?
yes,
All right. And this is a true and accurate copy of the bill from Small Hospital Innovations.
yes.
All right. Your Honor, I'd like to admit Exhibit C into evidence.
It will be admitted without objection.
Thank you, Your Honor. All right. So moving on to your injuries. What injuries did you sustain again? On and where?
On my left side of my forearm, I had a punctured wound and skin removal from the dog bite, and like swelling, my arm like swelled real quick, real fast from the puncture, and excruciating pain, this pain. I could not move my hand and my left hand to make sure it's okay, but when I move, cause the puncture. And that's about it. I can recommend. I can try to
Okay.
understand at that time.
How long did you continue to experience pain?
For I think a year and 2 months.
A year
Yeah.
and 2 months.
Yes,
Do
it
you
was
have
pain.
any? Yeah, okay. Do you have any scars or permanent marks from the dog bite?
Yes, yes, yes. The puncture and the teeth mark or something like that he left. Yes, I have that.
Okay. And I'm just going to show you a few photos here. All right, this first photo, and I'm going to pull it up again here. All right. Is this a photo of your arm?
Yes. And you can see
Okay.
the puncture mark at the bottom
All
when he
right.
punctured me. Yes.
All right.
When he
Does
had my
this
arm in
feel?
his mouth.
I'm sorry.
Hmm?
Say that again, Mr. Ferguson.
When he had when he had his when he bit down on me, you could see the puncture mark underneath my forearm.
Okay. Does this fairly and accurately show how the dog bite looked? at the time
Yes,
you were
yes.
hit?
It was worse than that, but yes.
Okay. All right, Your Honor. I would like to admit Exhibit D into evidence.
It will be admitted without objection.
Thank you, Your Honor. Okay, and I'm going to share another photo with you here. All right. Do you recognize this photo?
Yes,
All
yes.
right, and what is this a photo of?
This with a puncture mark and scratches from the dog bite. When I
Okay.
took photo, yes.
All right, and this is on the, what part of your arm again?
My left.
Your left, okay.
Yeah.
All right, and does this fairly and accurately represent the dog bite the day of when it happened?
Yes.
All right, Your Honor, I'd like to admit Exhibit C and, excuse me, E into evidence.
It will be admitted without objection.
Thank you, Your Honor. All right, and lastly, I want to show you one more photo here. All right, do you recognize this photo?
Yes.
All right, and what is this a photo of here?
That is the puncture mark and the bite marks around my arm from the dog when he bit me.
Right.
Yeah.
How long did you have to wear those bandages?
Ooh, about a year into a year and 1 month. Then I just started. I took the band-aids off. Yes.
Okay, and those are where the scars are now, correct?
Yes. Yes.
Okay. All right, Your Honor, I'd like to admit Exhibit F into evidence.
Will be admitted without objection.
Thank you, Your Honor. Okay, so just getting a little into how this affected you emotionally, can you tell the judge, do you now have a fear of dogs and now?
Yes, I have a fear of large dogs. Anytime I go into a establishment or anybody home, I have a fear of dogs. I just don't have that trust for them anymore. And I
Understand
was
that.
a dog lover, but I don't have trust for them anymore. I don't have trust for them anymore.
Okay. And
Yes,
did this
I just have
incident,
fear of dogs because.
all right. And did this incident affect your ability to participate in any type of activities or family life or hobbies?
Yes, yard work. I like to work in the yard and do my garden. It affects sometimes when I doing something, trying to do the community, like clean up and stuff like that, and picking up. Sometimes I feel a pain. I feel pain, and I stop and I sit down and I let the pain just the throb and just go away. Then I just try to I just deal with it. That's all I know. I just deal with it with the pain sometimes. From my forearm, my left forearm, because that's usually what I use, my left um, um, to pick up, sweep, or do anything with it. Sometimes I just feel pain, but now, you know,
Do you believe this, your injuries will continue to affect you emotionally as well as physically?
yes, emotionally, yes, 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 yes.
All right. Your Honor, those are all the questions that we have.
Mr. Ferguson, I did have one question. Was there any pain associated with the treatment? I've always heard that rabies vaccinations can be painful. Was there any pain associated with your treatment?
Yes, it was very, ooh, I describe the pain like a 10 when they took the needle and put it into the puncture area and moved the needle around, and that was with every shot I took, um, it was just painful. It's just a 10. Yes.
All right. Anything else, counsel?
Yes, Your Honor. At this time, we presented testimony and exhibits to show that Mr. Ferguson incurred medical expenses, as well as he had pain and suffering. He has scarring, emotional distress. We ask that, the court respectfully enters a judgment in the amount of $200,000 in this case, which represents special damages and general damages supported by the evidence.
All right. Court has heard the evidence presented. There is no objection. The case is in default. The evidence is presented and the request for $200,000 plus court costs is reasonable. So the court is going to grant that amount. And Ms. Barnes, if you'll just go ahead and prepare the order. Mr. Ferguson, I really feel bad because I'm a dog lover and I like big dogs. I have, love pits. But the problem is the owners, people who are irresponsible dog owners and who don't train their dogs and who don't control their dogs. And I'm so sorry for your fear that you now have and the pain that you suffered, because we have so many people who are irresponsible dog owners.
Yes, I understand. Yes, you're right.
I hope things get better for you, sir.
Yeah. Thank you. Thank you so much.
Take care. All right, Ms. Barnes, good to see you. Thank you.
Your Honor, thank you. We will prepare that order and submit it. I don't have any other business. May we and my client be excused?
Yes, ma'am.
All right. Good seeing you, Judge. Thank you.
All right. All right. The next case is American Express versus Paulette Glover. I see Ms. Glover is present. Is there someone here on behalf of American Express?
Good afternoon, Your Honor. Michael Parker here on behalf of American Express.
All right, Mr. Parker, Ms. Glover. This case is a case on a credit card account. Is that correct?
Yes, ma'am, that's correct.
Okay, you can take it off.
All right. So, Ms. Glover, the way this works is Mr. Parker, representing the plaintiff, American Express Nation, is going to present the case. This is in the nature of what we call liquidated damages, which means that there's a specific amount of damages based on the contract that you all had for the credit card. If there's anything that you have that disputes the amount that is currently owed, and you can present evidence as to that after they've presented their case, okay?
Thank you.
All right, thank you, ma'am. All right, so Mr. Parker, go ahead and present.
Thank you, Your Honor. This case is a credit card case with American Express. American Express extended credit to Ms. Glover, and Ms. Glover did default in the amount of $10,197.22. We submitted a motion for judgment on the pleadings based on the fact that in Ms. Glover's answer, there was no denial whatsoever in terms of the debt that was owed. As such, we did submit with the initial suit copies of the statements to demonstrate what the amount owed was by Ms. Glover. And so at this time, we would ask that the court would allow the full amount of $10,197.22 in addition to the court cost.
All right, Ms. Glover, the court has reviewed your answer, and your answer is in the nature of not a defense to the debt owed, the contract between the two of you, or the amount owed. It is in the nature of would be a hardship financially for you to pay the debt that is owed. And so that's not a defense to the contract. The court, unless there's a defense to the actual contract, meaning that it wasn't you who engaged in the contract or that you've paid the contract completely off, then the court is required to grant judgment in favor of the plaintiff. Now, I always say this. Once judgment is granted, you can still continue to have a conversation with American Express about a payment plan or how it's to be paid. They have several options under Georgia law as to how they can collect on a debt. I have nothing to do with that. Once I grant the judgment, I'm done. But I do say that the relationship between you and American Express can continue and the conversation can continue such that you may find some path beneficial to you to pay the debt, okay? So at this time, unless you have an objection to what has been pled by Mr. Parker on behalf of his client, I'm going to go ahead and grant the amount.
Okay, well, yeah, I have no, as far as paying it was not the problem. Once my husband passed, that my funds ended. And
Yes.
that's the whole problem.
Oh.
And all I'm living off is a pension and Social Security. So that's where the problem lies. I mean, I'm not trying to default on a bill, but I just don't have it.
I got you, ma'am. I understand. So at this time, Mr. Parker, the court is going to grant the amount of $10,197.22 plus court costs. And if you will go ahead and send that order in, you may have already done it because these are liquidated damages. We'll go ahead and get that signed. You're muted, Mr. Parker.
My apologies. Thank you, Your Honor.
No problem. All right. And Mr. Parker, is there, I guess, a way for Miss Glover to continue to communicate in case she wishes to try and pay the debt? If you want to include that information at the bottom of the order, then she'll get a copy of it.
Yes, ma'am, I will do.
All right. Thank you so much.
Thank you. May I be excused?
Yeah.
You may.
All right,
Ms.
thank
Glover,
you.
you may be excused. All right, the next case on the calendar is Jonte Jackson versus Jarvis Johnson.
Good morning, Your Honor. Sean Moore here, or good afternoon now.
Good morning.
We're here on behalf of the plaintiff.
All right, Ms. Moore. All right, and Ms. Roy, on behalf of the defendant, is this the case?
Yes, Your Honor. So the defendant, my client, there was a magistrate court trial, bench trial on December 10th, 2024. My client was unhappy with the result, so we appealed it to state court in order to get a jury trial and 6 months of discovery.
All right, Mr. Moore, so they're seeking a jury trial. What's the amount of controversy?
Let's see. Believe, give me one moment, Your Honor. Believe the award from magistrate was, it was a little over $9,000. My client's bills, the specials, are $2,033.
Okay, Ms. Roy, with respect to, is there a counterclaim?
There is no counterclaim, but we're disputing liability along with damages. So the total amount, they also requested $2,500 in lost wages. So from what I saw, we had the total special damages were around $5,000, and the court awarded $9,533 as well as $369.97 for court costs. So around 10K.
Hold on just a second, Ms. Roy, 1 second.
Okay.
I'm sorry, my mom's in the hospital, so any call that comes from a family member, I gotta take that. All right, so this is like a $10,000 case and we're seeking a jury trial.
Yes.
All right.
Yes.
Mr. Moore?
Yes, Your Honor. I have nothing further to add on what defense just stated as far as their basis for appeal.
Okay, so unless there's an objection, I'm trying to remember if there's a change in, because all the new rules with the tort reform about the amount in controversy that a jury trial, I know that you're not entitled to a 12-person jury, you're only entitled to a 6-person jury. So we will set your case on the jury trial calendar. All right.
Yes, Your Honor. Sorry, Your Honor. We would like 6 months of discovery as well.
Okay, this is a car accident case, right?
Yes, Your Honor.
Yes.
All right, so we'll go ahead and start discovery as if the case was filed in the state court.
Thank you, Your Honor.
All right. So I expect that I will see you all once you all start filing motions.
Yes, Your Honor.
All
Thank
right.
you.
All right,
And-
Ms. Powell, move this case to the court's jury trial track, and then we'll just monitor it from there. All right, thank you.
Thank you.
Thank you.
Yes, ma'am.
LVNV Funding LLC versus Teresa Kyle. Anyone here on behalf of LVNV Funding LLC? This is a contract for probably a credit card case. All right, no one's responding. Teresa Kyle. All right, Miss Powell, are there any issues with service in this case?
Judge, there should not be any, but I'll do a thorough check if you want to move to the next.
I'm assuming because neither party showed up, maybe they have worked out some agreement, but the court is going to dismiss for warrant of prosecution.
I'm gonna check on Odyssey just to make sure we don't have a another issue if you don't mind.
Same issue. All right, and just go ahead and let me know. The next case is Zakara Jones versus Latoya Maxwell, auto accident. Mr. Ahmed is here, and Mr. McCarthy.
Yes, good afternoon, Your Honor.
All right, so Mr. Ahmed is here for Ms. Jones, is that correct?
And Ms. Jones is also present, looks like.
All right, and Mr. McCarthy.
Ms. Jones is muted, it looks like.
Yeah, and Mr. McCarthy, you're here on behalf of Ms. Maxwell?
Yes, the defendant, Latoya Maxwell.
So, Mr. Ahmed, you want to begin your case?
Yes, Your Honor. So we filed a motion to withdraw in this one per my client's request. She's informed us that she no longer wants our representation. So pursuant to Ms. Jones's request, we've asked to remove this counsel.
All right, Ms. Jones, tell me, don't tell me what you and your attorney have discussed, but tell me a few things. Unmute for me.
You're still muted, Ms. Jones.
I'm sorry, it wouldn't let me.
There you go.
Excuse me.
No, I'm sorry.
All right.
Could you?
So when was this case filed? This is a 2024 case. So Ms. Jones, you're the plaintiff in the accident case, and you're trying to withdraw. You want this attorney to withdraw as your representative.
This is a 2023 case, and yes, I would like for them to withdraw from my case.
All right. So do you have any plans for someone else to step in and to continue to represent you?
No.
Okay. The problem with that is Mr. McCarthy can still file things that you would be responsible to respond to. And there are timing issues. If you fail to respond timely, that would be detrimental to your case. So because you don't know all the rules of civil practice, it is going to be an issue if you want to pursue your case, particularly since the defense has an attorney on the other side. I cannot make allowances for you. I cannot treat you any differently than I would somebody who's represented by an attorney. So if you wish to not have Mr. Ahmed represent you, you should probably consider talking to someone else about representing you, because there are a lot of rules that go with this. And a lot of times when people think, my mama is an attorney and she used to say, people look at us and they just say, oh, well, you're just talking. I can talk. But we've spent 3 years in school learning how to talk and write and speak before a court. So just as a warning, if you're going to let Mr. Ahmed go, you will be responsible for responding to anything until such time as you get a new attorney who puts himself into the law, into this.
Your Honor, just if I may say a thing or two, I think Ms. Jones has reached out to the State Farm adjuster and has been trying to negotiate a settlement of her case. And as far as I know, they were fairly close to resolving the case. But so I don't know if Mr. Ahmed is asserting a lien in the case or not. But
no plans to do so.
Okay. All right. So Ms. Jones, if you're going to settle the case, that's up to you. I will grant the motion to withdraw. I'll sign it today. So Mr. Ahmed will no longer be responsible for anything in this case. And then if you reach a settlement, that's fine. If you wish to continue the case, that's fine. But as I said, if you continue, there are rules and timing issues that you should be aware of.
Okay.
Thank you, Your Honor. And one other thing, I just wanted to make sure that the court had the correct address for Ms. Jones. I don't believe she actually received notice of this hearing. I forwarded that along, but just wanted to make sure that there was no.
Okay, well, that was the other thing. So if you're going to get direct notice directly as opposed to through Mr. Ahmed, we need to make sure that we have the correct notice.
So
wait a minute.
Powell, she sent me the notice in the letter. I was informed about the court hearing before Mr. Ahmed has informed me about it.
Okay, so Ms. Powell does have the correct address for you.
Yes, ma'am.
Okay, I want to make sure that I have the correct address for Ms. Jones. Is it 1321?
Mr. McCarthy, just don't say the whole thing out.
Yes, it
we
is.
do record and we do
Okay.
speak.
It is the 1321 address in Atlanta?
Yes.
Okay.
And just confirming, Ms. Jones, I remember when we spoke, I told you that you should go by the clerk's office to update your address. Did you already do that?
No.
You'll still want to do that.
Now, Ms. Jones, they have a new thing now, where if you go onto the website, they have QR codes that you may be able to update your address from your home, just by putting your camera on the QR code. So go to the website. It is the state court clerk, Clayton County. And our clerk's name is very unique. It's Tiki, T-I-K-I, Brown. So if you Google Tiki Brown, it is likely that the website will come up and you'll see how to get into it. But otherwise, the alternative is Clayton County State Court, because we have 3 different clerk's offices.
Okay.
All right, you got that?
Yes, ma'am.
All right. So Mr. McCarthy, Mr. Ahmed, anything else before we dismiss?
Nothing for me, Your Honor.
All right, thank you.
All right. Have a good day, Your Honor. Thank you, everyone.
All right. Thank you. All right. Ms. Jones, you're free to go at this time. Gentlemen, you're free to go. Capital One North America versus Barnett Chapel.
Hello, Your Honor, Miss Haywood.
Miss Kyle, I was calling you.
I've been here trying to unmute my phone. I'm sending messages. I just found out how to unmute my phone, but I was able to send you a message.
Okay, hold on.
I'm sorry.
Okay, hold on. So I called the case of LVNV funding versus Teresa Kyle.
Yes, ma'am.
No one showed up on behalf of the plaintiff. So that means that this case is going to be dismissed.
Yes, okay. I've been here for an hour and I'm
I thought I'd
sorry.
seen you, but I couldn't. I called it 3 or 4 times and I couldn't get anyone, but you're fine, ma'am.
And
Thank
I
you
did
so
double
much.
check service, Judge, through Odyssey. They were attached to the case.
So they were served.
Yes, ma'am.
All right, so there's no problem with that. All right, so yes, ma'am, the case was dismissed for warrant of prosecution on behalf of them.
Okay, thank you so much.
You're welcome, ma'am. All right, so Capital One North America, anyone here before them? Barnett Chapel.
Christopher Warren on behalf of Attorney Kellen Kidwell.
I'm sorry, on behalf of whom?
Kellen Kidwell, she was the attorney for Mr. Chapel. And it's a motion to withdraw.
Okay, so the defense attorneys tried to withdraw from representation of defendant?
Correct.
Okay. She's not here?
No.
Are you taking the case?
No. I'm making a limited appearance for this hearing only.
Okay, the reason I'm having these hearings is because I found too many times I get pressure from attorneys to let them out of a case, but then they haven't given proper notice they say they have, but then when we check the address, the person's not at the address, or they haven't gotten notice of the intent to come off the case. Mr. Chapel, I'm going to send you something to ask you to unmute your device so you can talk to me.
I'm here.
All right. Yeah. Do you know how to turn your camera on for me?
Let me see. There we go.
There you are, sir. All right. So what is the attorney's name again, sir? Mr. Warren?
Ma'am, say that again. I couldn't hear you.
You're here on behalf of whom?
Kellen Kidwell.
All right, so Mr. Chapel, Kellen Kidwell, your attorney, has sent a motion requesting that I allow her to come off the case and not represent you anymore. Are you aware of that?
Yes.
Okay. Did you receive that information from her?
From Capital One?
From Kellen Kidwell.
Kellen Kidwell. No, I just received something from Century Law. That's all I received.
Okay. Is Century Law the firm that Ms. Kidwell represents? Works with Mr. Warren?
Yes, it's a debt consolidation plan, and I've been informed that Mr. Chapel wanted to terminate our relationship, and he did not want to participate in the program with Century Law Firm.
Okay, sir, is that true, Mr. Chapel?
Yes.
All right, so I'm going to go ahead and sign off on this, but Mr. Chapel, I just want you to know then you'll be responsible to respond to anything filed on behalf of Capital One. You'll, if the attorneys file anything, they're going to serve you and you'll have to respond to it. Sometimes there are timing issues. And if you miss those timing issues or you don't respond, it may be detrimental to your case. And also, a lot of times people think just because they're talking to the other side that they are also protecting their rights with respect to the lawsuit. You can talk to them about resolving the debt and still have a problem with the legal part because you're not following the legal rules. So please understand that there can be two things going on. One can be, I'm talking directly to the debt collector. I'm trying to get this resolved. But it can also be that they're pursuing a legal case against me and I need to pay attention to that also. You got me?
Yes. Okay.
All right, sir. So we'll go ahead and sign off on that motion to allow that attorney to come off the case, and we'll get you a copy of that, Mr. Chapel.
Thank you.
All right. Thank you, sir.
All right.
That concludes my business, Your Honor. May be excused.
You may be excused.
Thank you.
You're
Good day.
welcome.
Good afternoon.
All right. Thank you. All right. So I think that is
We have the Spalding County case, Judge.
I know, I see a lot of people on here though. Anna Zapeda, Daryl Swan, so I'm wondering if I missed something.
No, Darrell Swan is a witness.
Okay.
Good morning, Anna.
Good morning. Anna Zapeda.
She's my client.
Okay. All right, and Daryl Swan
is a witness, but Your Honor, I filed for a jury trial in this case as well on September 25th, 2024. We're going to engage in at least some limited discovery.
All right, so jury trial request has been made. What's the amount in controversy?
Well, it was originally $8,000, but $8,160. But now he's held the vehicle for all of these days, going on a year now, and so we'll be asking the jurors to be compensated for those days as well, but not having access to my vehicle.
Does it exceed the 6-person jury amount?
No.
Is that one?
No, ma'am.
Okay. All right. All right, Mr. Mayfield.
Well, we won down below a counterclaim judgment for $3,705 plus $555 attorney's fees, and that's damages and storage fees, and she's still not picked her car up, so that's another year of storage fees. So our counterclaim will go up. I don't know the 6-person limit off the top of my head. I apologize, but
that's okay. It's all new. All right.
We'll be asking.
So
ours is contract though, not tort.
I got you. So this is a Spalding County case. I'm coming in as the judge who took over because the other judge was conflicted out. So we're going to put you on a jury calendar, trial calendar. We're going to go ahead and allow you to have some limited discovery. And I will work with Judge Thacker to make sure that I can come and sit in his courtroom and have a jury trial on this case. They have limited space. And so I generally don't do jury trials by video. So I'm going to have to work with his calendar. I know they're trying to open another courtroom, but neither here nor there. So they have limited space. I'm going to work with the clerk's office and Judge Thacker's office to try and get us before a jury and figure out how best to do that. I anticipate at best we'll probably be looking at the first of the year. So after discovery and, trying to work out all the kinks. All right. Is there anything else I need to know prior to this case going on the jury trial track?
Will you be generating an scheduling order to this effect? And if so, can we file dispositive motions during the discovery period or maybe a separate order?
Yes, I will hear motions during the discovery period. We'll go ahead and set up a scheduling order for you all. And if you all, if there are, we'll go ahead and let you review it. If there are any objections or anything that I haven't anticipated, then let me know.
Yes, Your Honor. All
right. So, and also, court reporters are starting to be rare as hen's teeth. Miss Walker, we need each court reporter to train 2 more. So I just got to make sure that I have all of the moving parts together, but I'll start talking to Judge Thacker about that today.
Madam Judge, Your Honor, I've sat with you, and I have our floor staffed almost now,
I know you do, and I appreciate you. Like I said, I need y'all to start making sure that you raise this other generation of court reporters. I appreciate you for that.
We're trying. I just started adjunct professor out of New York, SUNY system. So
yeah, my mom graduated in the SUNY system. Congratulations.
Yes, ma'am. We should be turning out 25 in about 18 months.
All right. Well, tell them to think of us.
Yes, ma'am.
So Ms. Hale, Mr. Mayfield, we're going to get you a scheduling order. We'll get you on that track. I'll start working with Judge Thacker, and then we'll make sure that we can get this case heard, because I know it's been kind of hanging for a minute, and we'll go ahead and get you heard de novo, as it were.
Thank you, Your Honor.
All right. All right. My staff attorney is Ms. Powell, Kiara Powell. So if you have any issues, Ms. Powell, you're probably getting the emails from Ms. Powell, and then we'll go ahead and get that out.
All right. Thank you, Your Honor.
All right. Take care.
Bye-bye.
You too. Bye-bye.
All right, Ms. Powell, did we have anything else?
No, ma'am, our business is complete.
All right, ladies and gentlemen, thank you all.
We only have traffic court tomorrow, Judge. Sergeant will meet you at the court, at the office.
All right, thank you.
Bye. Bye.